felony assault, burglary by habitation, and now a failure to ID.
Your Honor, we have a case that's not on docket.
Right from the start, this defendant is drowning in cases: felony assault, burglary, failure to ID. Ever notice how once someone racks up charges like this, it snowballs? Judges don't forget patterns, especially when the defendant is already tangled up in multiple dockets.
Today, but she's got a warrant they filed on her last month for a case that happened in August, and she wanted to turn herself in. The case number is 2553 536. Brianna Beck.
You are Brianna Beck.
Yes.
Ms. Beck, you are now charged with theft. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Judge, can I get the case number, please?
255-3536.
3536?
Ready?
Yes. On December 17th, 2024, an officer...
And here's where it gets wild. This isn't one impulsive theft. We're talking about multiple store hits across different counties. That's organized shoplifting territory. Courts treat repeat offenses much harsher, especially when they involve calculated tricks like fake returns.
Reviewed an OR, an offense report of a theft on September 17th, 2024. According to the report, the complainant reported that the defendant, known to the complainant by name and site, stole 2 espresso machines on August 9th, 2024. The complainant stated the defendant committed the theft at 3 other store locations. The officer reviewed documents that there were theft incidents at 4 HomeGoods locations. The first incident occurred outside of Harris County, Texas. The second incident was investigated by the Harris County Precinct 4 Constable's Office. The third incident occurred on August 9th, 2024, where the defendant and an unidentified female entered the HomeGoods and entered the line to make a merchandise return. Once in line, the defendant ran toward the back, where she selected 3 sets of sheets and then walked to the front of the store and rejoined the female in line. The defendant then placed the sheets on the counter and provided the cashier with her state ID. The system denied the non-receipted refund due to excessive returns without a receipt. The merchandise was then returned to the defendant. The defendant and the unidentified female then left the store, passing all points of sale without attempting to pay. The value was $599.99. The fourth incident occurred on August 9th, 2024. The defendant arrived alone at another HomeGoods location and proceeded into the store with an empty shopping cart. The defendant selected 2 espresso machines and then walked to the front of the store and passed all points of sale without attempting to pay, and the security sensors went off. The value was $999.98. The officer reviewed the surveillance footage from the third and fourth incidents and compared them to the defendant's previous booking photo, and they were a match.
All Marshall's HomeGoods? Is that what it is?
Yeah.
Okay. She's on bond for a theft. She's on bond for a gun case with us now. Where's the first theft?
This is classic judicial muscle. Translation: keep testing me and I'll lock you up with a bond so high you'll need a lottery win to get out. Judges often use big numbers like 5,000 as a scare tactic to push compliance.
The first theft is from a Walmart judge. $121.
Ms. Beck, I'm going to find that there's probable cause to go forward with the case, and I'm going to tell you now, I will do everything in my power to protect every person, place, thing in this county. And if I have to put you in custody and make your bond $50,000 because you continue to become a danger to our city, I will do it in a heartbeat. Do you understand me? I'm ordering you not to go to any Walmart, any Marshall's, HomeGoods, in anywhere. And I'm going to put a GPS monitor on you so I know where you are at all times. You are not to consume alcohol or illegal drugs. And I'm sending you now for a test so I know what, if anything, is in your system. You're to test and then you're to come right back. Do you understand?
Yes, sir.
Do you have a job at this time?
Yep.
What do you do for a living?
I'm a reservationist.
Okay, I want proof that you have a full-time job because that is now a condition of your bond as well. I want to make sure that you're working full-time as well.
And Your Honor, the defendant is also a complainant in this court as well. I need to bring up, we've reassigned these.
Uh-oh, rolling your eyes in court? That's like spitting in the judge's coffee. Attitude matters. Judges weigh body language, tone, and respect. And bad courtroom behavior can push bond conditions higher, even when the law is already stacked against you.
Cases so that we can deal with it, and so it's on separate prosecutors. Like, I have the other defendant's case assigned to me, and Abigail is assigned this case. If that makes sense. She is
You
listed
guys
as so she is listed as the complainant in a separate case also in Court 5.
In what regard?
So she,
Like in an assault or something like this, of this nature?
yes, it's an assault, Your Honor. And to.
Okay, so you got, I mean, you divvy it up how you want.
Yes.
Yes.
Because I don't want her to pick up fourth case.
Right.
No, we just want to
Sure
make
that-
you aware, Your Honor.
Yes.
I'm also ordering you not to be in possession of any weapons. Do you understand? These are your bond conditions. You violate these conditions, I'm going to revoke all of your bonds and I don't understand why you're having attitude. You have now 3 cases. You're rolling your eyes as if you have some kind of, we need to talk about bond. What do you suggest as far as a bond in this case, on the newest theft case?
We would suggest a surety bond on the case, Judge, and leave it up to your discretion in terms of amount, but I don't think a PR bond would be appropriate here.
Well, if you do make it a surety bond, we could ask for it to be low. She did show up here on her own volition today. And I think she's, at least for today, showing the right attitude about how to handle this from here on in.
Set your bond at $2,500. Cash a surety. No more PR bonds. Do you understand? I want to send her for a drug test right now. So Fleisha,
Judge, I can't send her until the bond has been posted, or else they'll take her into custody.
okay, then I'm going to give her a PR bond for now because I want to send her right now.
Yes, Judge. I'll still have to wait till that shop size.
Yep, go for it. Okay, I'm going to set the bond at $2,500. I'm going to give her a PR bond because I want to send her for a test now. You were to test and then you're to come back. Do you understand? Not leave until you sign our bond conditions. Please take a seat.
Do I have to be back here when she returns?
No, I'm not. I want to know what, if anything, is in her system, but I want proof within a week of today of full-time employment. Okay. And then depending on what happens with the test, when we come back in a week, we'll talk about how to go further. Okay. Thanks.
This is the dreaded field sobriety test moment. Glassy eyes, unsteady feet, failed walking test, textbook signs officers look for. And with a 136 breath test, that's way over the legal limit of 0.08. The defense here doesn't have much wiggle room.
Sir, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Sorry, Your Honor, I think I got the wrong cause number.
It's 2-555-746.
On March 15th, 2025, at approximately 2:15 a.m., the officer observed the defendant's vehicle failing to maintain a single lane of traffic. They also observed the vehicle to signal a lane change, failed to signal a lane change multiple times. A traffic stop was then conducted. The vehicle pulled over and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed a strong odor of alcohol on the defendant's breath and person. The officer then had the defendant step out, and they observed the defendant to have red, glassy eyes and be unsteady on his feet. The defendant stated that he had one beer at a friend's house, The officer conducted SFSTs on scene. 6 out of 6 clues were observed on the HGN. 4 out of 8 clues were observed on the walk-in turn, and 1 out of 4 clues were observed on the one-leg stand. The DIC was read to the defendant, and the defendant consented to provide a breath specimen. The results were 0.136 and 0.139.
What was the stop for again?
The stop was at 2:15 in the morning. He was failing to maintain a single lane of traffic, and then he also failed to signal a lane change multiple times.
All right, Mr. Turrubiates, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run him to see if he has any prior DWIs, please, and a license?
He does have a license and insurance, Your Honor, no prior history.
No prior DWIs.
All right. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, your bond will be revoked. You will go to jail. No more PR bonds. Do you understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel, and he'll tell you if and when you have to come back to court. If he tells me he can't get a hold of you, you pick up a new case, you drive without a license, or...
Now here's where things escalate. Weed plus a firearm. Even if marijuana possession gets a slap on the wrist, adding a gun changes everything. Suddenly you're looking at potential weapons charges, and prosecutors love to stack those.
It's not going to go well. Do you understand?
Yes, sir.
Okay. I'll have you sign a receipt, Victoria. You'll get with Fleischer for your bond conditions, and you guys are free to go.
Thank you, Your Honor.
Thanks.
Can I have your shoes?
Take care.
Morning, Judge.
Good morning. How's it going?
Good. How are you doing? Yeah. I have David Duran on the docket,
Okay.
and if the court has the time, I'd like to address the probable cause.
Okay. Absolutely. Of course. Are you ready?
Yes.
Okay. Please.
On January 11, 2025, an officer was on patrol and observed the odor of marijuana and a male to be smoking in a motor vehicle nearby the 8,700th block of Lazy Brook Lane. The officer activated his emergency lights and positioned himself behind the motor vehicle and made contact with the defendant. The officer had the defendant step out of the motor vehicle and advised the defendant that he had been observed smoking marijuana. The defendant stated he was smoking marijuana inside the motor vehicle because he did not want to smoke inside his friend's home. The officer observed the strong odor of marijuana.